Welcome back to the show. Today I'm joined by David Olswang, a partner at Nixon Peabody and one of the sharpest leasing minds in the commercial real estate area. We're going to talk about something that doesn't get enough attention, the lease itself. Not the building, but the piece of paper that actually governs how value is created, preserved, and lost in commercial real estate. Office is in the middle of historic repricing. Retail is quietly having its best moment in a decade. Lenders are working through a wave of maturities. And sitting underneath all of it are leases, some drafted 20 years ago for a world that no longer exists, and every one of them dictating what owners can and can't do with their properties right now. David has spent his career in these documents, and today we're going to get into what he's seeing, what's breaking, and what's separating a durable deal from a fragile one. David, welcome to the show.
Nice to be here. Thank you.
So, a little background. How did you decide to have a career with a specialty in leasing?
That decision was somewhat made for me. I graduated from law school and was starting at a small firm in Chicago, a mid-sized firm, well respected. And they asked me the first day, what area do you want to practice in? So I put down litigation. That was always the sexy part. Litigation, corporate M&A. And I went through a laundry list, and I think the last one on that list was real estate, where I was pretty illiterate. I took one real estate course in law school, but put it down there just to fill out the sheet. And they came back the next day and said, congratulations, you're in the real estate department.
Looking at today, what do the office and retail leasing markets really look like?
Definitely different. Definitely different. I'd say in office, we've definitely gone through cycles. And even today, we see coming back to the office and more of a commitment to office. During the COVID era, a warehouse industrial, that was everything because you had to be able to get products where they needed to go and nobody was going to the stores. Nobody's going to the offices though. But there is a commitment for people going back to the office. So what we had been seeing even a couple of years ago, which were contractions, space is getting smaller, so tenants staying but taking less space. We're actually now seeing more expansions, either through expansion rights under leases or just through negotiation based on space. Now, rental rates, that can vary market to market. The brokers know that much more than I do. I could input the numbers, but I don't, of course, dictate those numbers. Retail is a whole different cat. And what we've seen in response to the Amazon world is less apparel and less of that which you can buy with a click and more in the experiential world. And I'll tell you, you and I, we're not as young as we used to be, but we have a Walgreens that is a half a block from our house. And we needed shoelaces. And if one of my kids needed that, I said, oh, okay, we'll go to Walgreens. No, I'll just order it on Amazon. I go, we're a half a block. No, we'll go to Amazon. So 4 hours later, it comes. So it's just different. And you and I may still be more inclined to go, but definitely the next generation's not. So what we're seeing in retail, very different, is the experiential world, that which you can't get online. Restaurants would be one, but even things like axe throwing, putt shack, now very popular, of course, Dave & Buster's, all those. That's where we're seeing much more of the activity. And we're also seeing shopping centers changing to attract people with different types of amenities. People say it's the ending of retail. I think it's more the amending of retail, just reimagining it. And there still is a place for the shopping centers in this world and for people to go and for savvy landlords to capitalize on that.
What are trends based on the negotiations in terms of leases? And who has the upper hand? And what kind of concessions we're seeing for the first time?
There's a lot going on there. One thing we're seeing more of is we're seeing more allowance. I'll define that for those who aren't familiar. That is where the landlord is paying the tenant a certain amount of money for the tenant to build out its space. And that can get into the millions of dollars. Now, the landlord will recoup it over time, over the lease, and a component of base rent will be a reimbursement, not unlike a loan. It just gets amortized over the 5 years or 10 years. So we're definitely seeing that. We're also seeing, I actually alluded to this before, are these contraction options and termination options. It's where tenants are saying, okay, I will take the full floor, but I'm concerned that I'm not going to need that much space over this 5 or 10 year term, and I want a right to give some of that back. Or a total termination right, 5 years in a 10-year lease or 7 years in. If that happens, then the tenant needs to make a lump sum payment to at least let the landlord recoup those upfront costs. But I think the leverage is on the tenant side. The landlords very much need these tenants to fill up their spaces, retail even more. So by and large, tenants with good counsel can extract more concessions.
Let's go back to ground level and lay out to us what type of lease agreement do you have that the lease itself becomes the asset?
Let's just take an easy case. If you look at a property with a beautiful building, right, but vacant, and you look at that same building with a tenant that has great tangible net worth, paying above market rents, the pricing of it, of course, is extraordinarily different. So the purchaser of that property, of course, is buying the land and buying the building, but is really buying the rental stream. We go back to the Walgreens example, it's coupon cutting. Every month they're going to pay. But again, the world changes, and then who's saying that there's certainty there? So there are some landlords who like to buy these properties, let's say single tenant, triple net. Triple net means that the tenant is paying all the expenses. There's like indicia of ownership. So the tenant is paying all, and they're happy with that. And then there are other owners who are looking for the value add proposition. They would prefer the vacant building, and then they want to look for the right tenant. They feel they can extract a better deal and then be in position to sell it later for some multiple. But either way, the lease really is an undeniable asset for the deal, and it's saleability, its value, its financeability is all dependent upon how these leases are drafted. Are they financeable, right? Those are huge questions, and any leasing attorney should be thinking about that, among other things, when negotiating the deals.
So would you say that deals are getting done that are not based strictly on the leasing prospects? And is anybody financing deals where the value is in the building and a value add today in office?
Lenders are loath to lend on buildings that aren't revenue producing. So those deals get much harder. Now, of course, the purchase price is down if the property is vacant, but those deals are harder, right? I mean, you've got office, warehouse, retail. If it's fully leased, you have a much easier, subject to certain caveats, a much easier time selling or financing the deal, for sure.
So let's go back to what we discussed in the opening. Let's dive into the details of the lease. What provisions tell you whether a property is durable or fragile?
From a purchaser's perspective, if there's a deal and we're asked, and we are asked, to review the leases, there are certain provisions that, of course, we look at very, very carefully, closely. One is, and we alluded to this before, any termination options, any contraction options. Those are critical. You can't bank on those rents when the tenant has the right to leave. So there may be no difference, in effect, between a 10-year lease with a termination after 5 or a 5-year lease with a 5-year renewal, right? Both of those are the same, and that's important from a seller's perspective or purchaser's perspective, that those are viewed the same way, right, from the financing lens, because both of those only have that guarantee. So you have that issue. Another one which could be under the radar would be the assignment and subletting clause, which could be a yawn to some people. But you owner, landlord, have a really solid tenant. But if that tenant has a right to assign the lease to Joe Schmo, sorry about that, to Joe Schmo, that changes it significantly. And in that provision, for example, you could even have a sentence, one sentence that says, tenant, assignor, shall remain liable under the lease. Critical sentence. It's just one sentence in a document with 1,000 sentences. But are you losing that creditworthy tenant and getting this, local, or is that the initial tenant that you need, that you're banking on, remains liable under the lease? So that's critical. And there are even provisions where there are these what we call permitted transfers, where you have the right to assign the lease. A tenant has the right to assign the lease to an affiliate. Okay, fine. You say that's fine. But again, can that transfer change the creditworthiness of the responsible party under the lease? And is there joint and several liability that remains? And of course, is it possible that the assignor actually may cease to even exist, even if the assignor is to remain liable? So that's critical. And our job and I'll give another example, but our job as the attorneys, I think we've got two jobs. One is to be good draftspeople. And I think anybody does anything for 30 years should probably be pretty good at what they do. So that's the lawyer hat. And then I think there's also the counsel hat, right, which is to also make recommendations. Of course, the client has the final say. But just because we see this all the time, we could counsel to say how common we think this is, how likely we think the risk is of this happening. If the concept is fake, there's a doubt on a doubt on a doubt. Okay, it's possible, but it's not a risk-free proposition, leasing property, either as a landlord or a tenant. So we need to empower the client to make those decisions, and we're happy to provide our opinion. I'm a big baseball fan. You like baseball?
Yes.
Okay. Are
But
you a
you're
Mets
probably a
fan?
Cubs.
Well, at least you're not a Mets fan. I don't know when this is going to air, but things haven't been going too well for your Mets. I'm a big Cubs fan. In baseball, there's an incredible thing, and it's not intuitive, right? It's the concept of the error, or in not being an error if the fielder doesn't touch the ball. So there's a fly ball to Willie Mays, and he camps under it. It goes over his head, but he doesn't touch it. By rule, it can't be an error. Crazy. In law, where lawyers are often risk adverse, and maybe that's why we went into law and not in the business world, we're afraid to touch the ball, right? Or if you make a play and it hits your glove, then it's an error. So I do see a lot of attorneys, certainly the younger attorneys, who are much rather present options to the client and let the client decide. They can't be an error. I don't think that's good counsel. I think the good counsel is to say, yes, it could be chocolate or vanilla, whatever it may be. I think you're better off with vanilla. Here's why. It's not my decision. It's yours. It's your money. But I'm going to tell you why I think this is the right decision. Could it end up being an error? Of course. We all make errors. But I think they pay us to make that attempt. Okay. One aspect of that is really significant, and Svi, I'm glad you asked the question, is, and I'll go back to retail and how it's evolved. So when you and I each had full heads of hair and went to shopping centers for fun with our friends, if you remember those days, it was only retail. It was the candy store, the toy store, whatever. It was only retail. And the anchors, the major tenants, would put restrictions or prohibitions in their leases saying, landlord, you can't sell to a drug shop marijuana. You can't have a hotel. You can't have residential. No, we want this to be a shopping center. That made sense in the 80s. That is not the model today, and I guess we talked about that before for a minute. So and not only that, these anchors want these residential developments to be built. You have then you have a large group of people who are right there, and instead of dark space, you now have a more vibrant center of people coming to visit and whatever it may be. So you would think this should be easy. The anchor tenant wants an apartment building. The landlord wants to put in an apartment building. So let's put in an apartment building. It doesn't work that way. Because if the landlord wants to put in an apartment building, what does the landlord have to do? The landlord has to get consent. from this anchor, from an anchor that wants it. But anytime, here's a maxim, anytime a landlord has to ask an anchor for a concession, there's going to be something in return. And these anchors are struggling too, right? So they say, what, maybe we need to revisit a couple other provisions in the lease when we revisit this, right? Nothing is free. And again, I've been on both sides of these conversations. I don't begrudge anybody for it. It's a healthy discussion. But that is like a provision where if you have a client who wants to buy a center and they have this great vision of reimagining it, well, there may be some anchors that have, a place at the table. And those conversations are protracted, they're difficult, there's no certainty as to where that's going to land. So even when interests are aligned, like in this case, it is a real challenge. It is a real challenge.
Win-win is not a win in business.
It's win and win-win. Somebody wants to get a little bit more than the other. So yeah, now don't get me started on if it's something that anchor doesn't want. That's probably going to be DOA. But even when the parties say, yeah, this is a great idea, but by the way, we really should explore some other topics. They go, okay, buckle up. We're gonna be here for a while. But that's what makes our job fun.
Any other provisions that stand out in your mind that look benign, but tell you personally something serious about the deal and how it was negotiated?
Yeah, there's a provision that a lot of people will overlook that has real significance, and it's called the SNDA, which stands for Subordination, Non-Disturbance, and Attornment Agreement. And then you have to dig deeper and say, well, what the heck does that mean? Okay, so I'll try to explain this in 2 minutes or less, because we'll lose the audience very quickly. The subordination is stating that the lease is subordinate to the mortgage. And the tenant's agreeing that even though the lease was first in time, the lease will be subordinate. Now, what does that mean? That means if a lender forecloses, then a lender has a right to terminate the lease because the mortgage is superior, the deed of trust is superior. Okay. Non-disturbance. The tenant says, lender, I don't want you to disturb my tenancy. So if you're superior and if you foreclose, you still have to recognize my lease. Attornment, again, another word. Now, the tenant is going to attorn, in response, is going to attorn to the lender as the new landlord. Attorn, I guess, just is the same way of saying it recognizes the lender. These SNDAs are critical to the financing of a deal. The lender wants to get an agreement to make sure that it's superior and that it has certain rights when it steps into the shoes of the landlord. And the game there is, what are those exceptions? Like a lender says, yes, of course, I'll be your landlord, but I will have no obligation to pay any allowance that's owed under the lease because I didn't sign up for that. Totally reasonable. But the tenant says, wait a second, my deal is I'm getting $100 a foot to build out my space. So, and I'm paying rent over time to reimburse you for that, if we go back to the beginning of the call. So how can you be my landlord but not pay the allowance? Or not build out my space? The lender says, So you have, it's like 6 items that really get negotiated in SNDA. And these major tenants will often have their own SNDA form. They'll say, yeah, we'll sign an SNDA, but it's the way we like it. And the lender says, no. We have our own form. So when we look at deals, we've done these deals enough to know the troubles that are ahead, and that is you're going to have a very difficult time getting this major tenant, this anchor, and this lender to grant an SNDA, and there's not a deal unless that SNDA is signed. And in that regard, if I'm on the purchaser side, I'm often just on the sidelines. I say, okay, well, whatever you guys want is fine by me. And certainly if I'm on the seller side, I say, look, whatever you want. But that's a provision that can really be a significant issue when doing a deal. And SNDA provision is buried in the back of the lease, Section 20, Section 30. People get tired by then. It's an exhibit. Who looks at small print? So you have to keep your strength up when negotiating these leases and thinking about something that will be relevant not necessarily today, but years from now.
What's your strategy for negotiating leases? What's your secret sauce that the young attorneys can learn from, or the purchasers and sellers?
I think to the extent that it just comes down to leverage, right? A landlord or a tenant says, take it or leave it. It doesn't have to make sense. This is the deal. Okay, there's no more lawyering to be done there, other than, if you're a poker player, is this a bluff? Is it not a bluff? Are you going to walk away? Okay, and I do enjoy a good card game, so I also enjoy that aspect of it. So that's a possibility. I do think generally that attorneys and business people are reasonable. And so if you get to a conversation and you can make a cogent argument as to why something does or does not make sense, you have a much better chance of getting that provision revised in a way that makes sense. In my experience, maybe yours as well, people are much more strident in emails. You talk to somebody, it's a little harder. It's a little harder to stick your thumb in somebody's eye when you're actually, talking to them. I'm going to give an example, and again, I'll try and do it more just as a demonstration, but again, I'll also try and keep it short. A tenant has a renewal option, and the lease may say, provided tenant is not in default, tenant has a right at the time of notice or at the time of the renewal term, tenant has a right to renew for 5 years. Now, that sounds pretty benign, but words have meaning. And the logical meaning to that is, if I, as a tenant, give a notice and there's no default, and let's stipulate tenant shouldn't be in default. It's a bad thing. But these things do happen. Or maybe we're not sure there's a default. Tenant gives a notice, everything's fine, okay? And there's like 9 months notice. And 1 month before the renewal term, there's a glitch in the system. The tenant's rent wasn't paid on time. Notice came. If there was a notice requirement, somehow the tenant missed it, and now the tenant's in default. And I will tell you another provision in the lease, it will usually say that a tenant doesn't have a right to cure after its cure period expires. Okay. So now the tenant's in default, and the renewal term's commencing, and now the landlord has a right to say, by the way, your renewal term is now null and void. And you've got 20 days to leave. And the tenant has no place to go because the tenant was banking on 5 more years. So the concept doesn't really make sense. I understand the landlord may not want a tenant that is defaulted, but the landlord has default remedies, which includes the right to terminate the lease. You could kick the tenant out, but to kick the tenant out on 20 days is onerous, pretty draconian. So when I'm representing a tenant, I may strike that proviso. And on the black and white of the paper, it may seem chutzpah. Okay, well, you're defaulted, you want to renew, we don't want you, you haven't paid rent for 6 months. I go, we're not talking about that. I said, I respect the words on the paper. So let's have a conversation where if we're going to spend countless hours and countless thousands of dollars negotiating this, and if we all agree, because we're in this profession, that words have meaning and significance, then let's have respect for the words. And let's come up with language that protects the landlord. Again, I represent landlords all the time, but also protects the tenant and doesn't allow for this possibility. When the landlord's counsel may say, well, why would we ever die? I don't know. Maybe you don't like the guy. Maybe your brother-in-law or sister-in-law wants to move into the, I can't guess as to that, but all I can do is look at the possibilities that exist based on the language that you and I are negotiating, and that these parties are going to have to live with. Let's see, a big difference between a lease and a purchase and sale agreement. A purchase and sale agreement, somebody buys, somebody sells, they shake hands, they go their separate ways. Everybody should live and be well. Maybe there's some survival of warranties for 6 months, 9 months, but that, whatever, put that aside. But a lease is a marriage. Not always a happy marriage, but it's a marriage for 5 years, 10 years, 15 years, it could be 30. So we're asked in this document to play out what's going to happen over years and years. And the English language isn't precise enough, and we aren't prescient enough to come up with everything. So we have to kind of work within our own constraints to try to put together a document that at least on day one makes sense, breathes, and allows for the parties to work together when issues come up that the lawyers weren't smart enough to come up with. If I tell you one more story. This is February of 2020, and the story is actually quite relevant to the example I gave. And I was lecturing on leasing. You can imagine how exciting that is. So I'm lecturing to the real estate group, and in fact, I was talking about this exact same thing, the proviso, provided tenant's not a default. Nobody cares about this fee. Nobody cares about this, but Allswang cares about it. So I'm going to talk about it. It was a 1-hour lecture discussion. The last 5 minutes, I said, I do want to raise one issue that I've been hearing about, this thing called COVID, and people are asking if COVID can end up nullifying leases, or is it considered what we call force majeure, like acts of God? And my thought is this is not really a big issue, and it doesn't really apply. Again, if I give it more than 3 minutes, it was a lot. Well, March 2020 happens, and for the next 6 months, that is what we focused on every single lease. And so it just tells you about not being able to see into the future. Now, every lease has a COVID provision. I think the Y2K provisions are now taken out of leases. I still see that, if you remember that, if you're old enough for the Y2K and the world was going to end. So leases generally get longer. Anything happens once, okay, we're gonna solve for it, and then you rarely take provisions out. But that example, the lecture that I gave on that was on the COVID provision. Okay, that was a fun time.
It's a fascinating perspective how leases to marriage, and it stays, and I guess that's why the contracts get longer and longer, because like you said, they just keep on stacking up provisions, and none of them ever come off the table, because who knows? We just keep adding.
They never come off, and suddenly we just say that, well, this is in every lease, so we're not going to even ask about it. I once, a couple times, spoke at Ida Crown Jewish Academy, where all my kids went to school. They have like a pre-law course, and lawyers come in every now and then to speak, and so they asked me to speak about leases. And I showed them, I said, here is an LOI. It's 3 pages. This is what I get from the client. And the client says, turn this into a lease. So I had that and said, and here's what it turns into. So there's a lot to talk about when you're going through a lease. And again, it's really important to understand all the provisions and how they all interrelate. And I think, again, that just comes with experience.
So let's talk about the flip side of that. What we talked about was how modern times or changing times add more provisions. What provisions do you see that haven't become outdated, but they're actually counterproductive today, that they're hurting people because the assumptions that they were built on have totally flipped?
Well, I think we gave one example, like with the residential restriction, right? That doesn't,
Right.
it's not good for anybody. But you have that. Another provision, and this kind of cuts both ways. And again, I'll try to summarize it quickly. So landlords incur certain expenses to keep up a building, and they pass through those expenses to the tenants. We talked about that triple net concept before. Janitorial, electricity, snow removal, whatever it may be. The tenants want the landlords to keep these buildings up and for these buildings to be in good condition, repair, fine. There is a lot of tension when it comes to capital improvements. So a landlord spends multiple millions of dollars fixing up the lobby. Now, there are easier cases. You say the landlord is spending millions of dollars to put in ramps because it's to comply with law. So let's put that aside. Millions of dollars. Now you have a beautiful lobby, and so then there are two considerations there. One is a tenant can say, and I might give both perspectives. The landlord says, "Look, you tell us to maintain this building as a Class A building. We need to do that in order to fill up the space, in order to have the money to do all these things you want us to do." The tenant says, well, sure, but your $80 million building is now worth $82 million. So you're going to pass that cost through to me, but then you're going to sell it and you're going to recoup it there as well. So you're getting it twice. And the landlord says, well, yes, but you're here for 5 years and you want this nice lobby. So that's an example where there's even more tension is when it comes to efficiencies, LEED certification. Landlords, which actually causes utility bills to go down through this efficiency. But the landlord is going to spend potentially millions of dollars to have savings of thousands of dollars, but thousands of dollars over 20 years, 50 years, right? So there's a huge outlay, and then there's a savings over a much longer period of time. Well, the tenant says, that's all lovely, but I'm only going to realize this benefit for the couple years I remain in the space. How are you going to pass? How am I benefiting from it? Yeah, sure, to the extent that the costs go down, I'm benefiting. But if those costs exceed the savings, that's a net loss for me. So provisions in leases where, again, it just depends on whose side you're on, that either restricted landlord's ability to pass through those types of capital repairs, or on the other side, that completely allows the landlord to pass through those capital repairs. Both of those actually have real limitations and are harmful. There is the story, I don't know if it's apocryphal or not, but it certainly puts a jolt in the young leasing associate, where there was a tenant that was leasing an entire building, and the landlord had a right to pass through capital repairs, but not on an amortized basis. So the landlord, in the last year of the lease, undertook this very elaborate capital repair, multiple millions of dollars, and was able to pass it through to the tenant all at once. So, and this is buried in an operating expense provision, common area maintenance provision, however, there are different terms for it. If I were a benevolent dictator, I would say we have to use the same term always in all leases, base rent versus fixed rent. I would fix all that, but I don't have that ability just yet.
I imagine since you work as a lawyer and not an arbitrator, you're not, when you're hired by somebody, you're drafting for that side and not drafting fairly.
Not necessarily. So different clients have different temperaments. Our time isn't cheap. The humor is added, that's just value add. They don't pay for that. But our time is expensive. And so I say to the client, I could revise in the way that's most, I'm sorry, it depends if I'm landlord or tenant. If I'm the landlord, I can start with a form that's really onerous on the tenant. And these tenants may just accept it. Great. But they may also come back with a lot of comments. And now you have to decide leverage, just going to say no, or do you need this tenant, then it's going to take even more time. So do we start with the 10 on the 1 to 10 onerous scale and could have a big fight? Or do we just go in the middle and hopefully get the deal done faster? A little less money for David, but better for client. Similarly, when I'm on the tenant side, I say, look, I could revise. I say, look, this lease is pretty good. I can make some changes, or I can make really some significant changes, and who knows? They really want you as a tenant. They need you for this space. You're leasing 100,000 square feet, and that's really another variable. How much leverage does the tenant have, or does the landlord have? The bigger the tenant, the more leverage the more the tenant has. So there's a strategy there in where you want, how much you want to push, either on the landlord side or the tenant side. Are you looking to get the best deal, or are you looking to get a fair deal? I will say, Svi, from doing this for as many years as I have, clients want the best deal and they want it done as quickly as possible. And I tell them those two conflict. I said if you want to push for the best deal, that will take longer. If you want to go for a 5, that's usually one that you're going to get sooner. So,
I assume with all your experience, you could probably get a feel for the type of client or the type of adversary, the one that the client, that the opposing counsel is representing, and probably make a decision based on that, just from experience and from understanding what you're up against.
Well, that's absolutely true. And our fraternity, sorority, I don't know if there's a combination of the two, whatever it may be, it's not that big. And how many leasing experts are there in our world? Some. I've often gone up against other counsel multiple times, and we may just say, let's just conform this. We did this dance before. Okay, well, we know where we're going to end up. Let's get there. Let's get there faster. And that's great. Or I may have worked with that same law firm, if not the same attorney. There's some firms that do leasing work around the country. They're great, all top quality attorneys. I say, look, I worked with your partner on another deal. I'm very glad. I speak with the client first to make sure my client's in agreement. I say, look, I believe this is a fair deal. I think these provisions, if you want to get to a deal quickly, we do that. There is a lot of that. I do tell clients, don't fall for the theatrics. Somebody screaming, somebody saying they've never seen this before, they've never heard it. It's an insult. It's an outrage. Somehow it's the worst. I said or here's a good one. It's not market. What you're asking for is not market. I'll tell you, in the history of the world, that means that is inconsistent with what they want. That's all that means. I don't know what market you're talking about. Never argue if something's market or not. On the other side, I'll tell the client how often we get it. But those are the games that are played. And if you get rid of the smoke, you say, okay, they said it, they feel better about it. Now let's just focus on the substance to see if we can get this done. Most attorneys are reasonable. To the extent they're not, it's usually because their clients are reasonable. Sometimes, I don't know if I should disclose this, sometimes the clients are really angry with each other. So I'll call the attorney on the other side. I'll say, okay, what do you think we should do on this? And we talk about it. And it's the most pleasant conversation you could possibly have. I said, okay, but let's do this. I'm going to go back to my client and say that you and I screamed at each other for 45 minutes. And here's what we came up with. Okay, fine, good. That's what we're going to do. We're saying we screamed at each other. So, okay, we don't have to scream. So sometimes that's the way, and the client feels better that we fought really hard for it. But again, we just focus on what the goal is. And the clients want deals done, and so they want deal makers. So we're absolutely tasked with that.
One last question before I let you go, and I appreciate your time. Before you go back to that note closing today.
I hope so.
Is there another document, if you had to pick out one, aside from the leases, what's the one document that people should look out for that can cause them trouble that they think is really not on the map?
It's a great question. I actually think there are two documents. One is the SNDA, again, which people just, they roll their eyes and they move on, and a lot of people just don't understand that document. And I would say to any young attorneys who are listening to this, that is a document, who do leasing, that's a document that you really need to understand. There's one other document, and it's called alternatively, landlord lien waiver agreement, and it's where the tenant may have a lot of valuable equipment in the space. So again, it depends on what we're talking about. If it's an office, it's probably not the case, but it could be a warehouse, a lot of equipment. And the landlord has a security deposit, right? That's pretty well known. But then there's also this concept of the landlord lien. And the landlord will put a provision in the lease that says, if you owe me money, I can lien, and you don't pay me, I could put a lien on all the equipment in the space. Well, again, that equipment could be worth millions of dollars, millions upon millions of dollars. So there are a couple of issues with that. Obviously, as a tenant, you'd want to push back generally. You'd say your security deposit, that's the security you're going to get. Or you may actually have financed that equipment. And you may have your own lender that has a lien on that equipment. It's not a lien on the property, of course, but a lien on the equipment. So say, I can't give you a lien. My lender has a lien. So then the landlord says, well, I want my lien to be subordinate. At least I get something. And so this landlord waiver or lien agreement, if it ends up getting negotiated, is what rights does that lender have to go into the space to get back that equipment either before or after the lease has expired. And that becomes a huge issue where, again, depends where you are in the deal, but a lender may say, I'm not going to give you this equipment unless I have this waiver in place. And the landlord says, well, I'm leasing the space to you, tenant, not to the lender. But the lender wants 60 days after termination to be able to go in and get because the lender may not know that the lease was terminated. So I need 60 days after the lease has ended to get my equipment out. The landlord says, yeah, but I already want to lease the space to somebody else. You see the tension, Svi? It's not easy. So this document is one also that you see a little provision that says, well, there's a landlord lien, but it's going to be subordinate to a document to be negotiated by the parties. An agreement to agree is, of course, unenforceable. It doesn't mean anything, as we know. So that document, really important, really to understand it on the landlord side, really to understand it on the tenant side, and to be able to advocate for the position one's looking for. That really could also make or break a lease if that waiver agreement or subordination agreement is not in place.
Thank you, David. This has been enormously valuable. I think what comes through clearest from this conversation is that the lease isn't a document you sign and file away. It actually lives together with the entire relationship throughout the next 10, 15, 20 years. And every provision is a decision about who bears the risk when things change. And in a market like we're seeing, where things change fast, we understand the importance of all this. For anyone listening who's signing leases right now, whether you're a landlord, a tenant, a lender, or an investor, the takeaway we're hearing today is pay attention to the provisions that don't seem to matter today, because they're the ones that will matter most when the market turns, when a tenant struggles, when you want to sell, when you need to reposition. Thanks again, David, and until next time, it's been real. We really appreciate it.
Thank you.